All right. Good morning, Connecticut, or my favorite state to spell because I say Connecticut every single time. I couldn't. That's left over from third grade. I couldn't figure out how to spell y'all's state, and I got it now. So, good morning. I am Kurt Mabus. I'm a lieutenant colonel in the United States Air Force and an attorney here in Colorado Springs, teaching law at the Air Force Academy, an alum of the We the People program. Turn over to Richard.
Good morning. My name is Richard Leiter. I'm a professor and director of the Law Library at the University of Nebraska College of Law. I'm coming to you from Lincoln, Nebraska, the heart of the heartland. I've been judging state competitions now for about 15 years, and this is my first time at the Nationals. So go easy on me. Thank you. You're muted.
Still
Canada.
muted.
It's their first time at the Nationals too. My name is Candida Steele, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and I've been judging in this program for 20 years, and it's the highlight of my year. So I'm really glad to see you all. Cheers.
All right, if you could introduce yourselves and your teacher, please.
Yeah, good morning, judges. We are Unit 5 from Staples High School in Westport, Connecticut, and we're here with our teacher, Mrs. Cameron. My name's Alex Harrington.
My name is Rashad Mandayam.
My name is Natalie Bendera.
My name is Katie Simons. Judges, thank you for having us, and we are ready to begin.
All right, great, thank you. Well, no surprise, we'll do question number 2 today. I'll read the question and then have you respond. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree with this quote by Thomas Jefferson, or disagree? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights? And which are more important to the preservation of liberty? Over to you.
In Federalist 84, Alexander Hamilton argued that adding a Bill of Rights would afford a colorable pretext to more powers than were granted. However, Robert Yates rightfully countered this in Brutus II, arguing that other rights are not necessary to be resigned in order to attain the end for which government is instituted. A Bill of Rights establishes citizens' rights through both positive and negative rights. Therefore, we agree with Thomas Jefferson.
The Bill of Rights codified Locke's theory of natural rights, which holds that humans are granted certain liberties by God and that under a just government, no one ought to harm another in his life, health, liberty, or possessions. Alarmed by the initial lack of a Bill of Rights, anti-federalists appealed to Locke's philosophy. As Richard Henry Lee wrote, there are certain unalienable and fundamental rights, which in forming the social contract ought to be explicitly ascertained and fixed. In 1833, the Supreme Court held in Barron v. Baltimore that the Bill of Rights applied only to the federal government, but through the Due Process Clause of the 14th Amendment and selective incorporations, most rights have been made applicable to the states. The first of these cases was Gitlow v. New York, which incorporated the free speech clause of the First Amendment. In Palco v. Connecticut, the court formally established the doctrine of selective incorporation, ruling that the 14th Amendment's Due Process Clause absorbed certain fundamental rights and incorporated them applicable to the states.
While the National Bill of Rights ensures protections for all, states' bills of rights preserve local values and can provide extra protection the federal government does not. For instance, California's Bill of Rights outlines protections for property rights and outlaws discrimination of race, sex, color, ethnicity, or national origin. Conversely, the National Bill of Rights provides final protection to Americans from radical provisions in state bills of rights. 8 states still include language in their constitutions requiring office holders to hold religious beliefs. The Texas Bill of Rights requires that office holders acknowledge the existence of a supreme being. However, because of the Supreme Court decision in Torcaso v. Watkins, ruling that such a requirement is an unconstitutional encroachment on the First Amendment freedom of religion, such mandates are unenforceable. In a federal system, localized powers such as policing powers and authority over education are reserved to the states. However, the National Bill of Rights provides a mechanism by which the federal government can ensure that the states provide for the fundamental liberties of American citizens. In Gideon v. Wainwright, the Supreme Court incorporated the Sixth Amendment right to counsel by ruling that it applied to criminal defendants in state courts. As a result, states are now required to appoint and fund attorneys for defendants who cannot afford to obtain counsel.
Rights can be categorized into two types, positive and negative. Positive rights, like the Sixth Amendment right to a speedy and public trial by an impartial jury and right to be informed of charges, and the Seventh Amendment right to a trial by jury in civil cases, require the government to provide a service. Negative rights, like the First Amendment right to free speech and religion, and the Second Amendment right to bear arms, restrict the government from encroaching upon one's freedoms. Negative rights are more important to the preservation of liberty. The Constitution was designed to limit the government, so it's more important to restrain the government than to affirm the rights of the people.
Negative rights also provide citizens an avenue to advocate for their positive rights. Without the First Amendment, Americans lose the ability to speak up if their positive rights are being threatened. For instance, the Capital Crawl of 1990 persuaded Congress to pass the Americans with Disabilities Act and clearly demonstrates how negative rights protect our positive rights. There, 1,000 disabled individuals protested the lack of accommodations in public spaces, thus using their First Amendment negative right to gain the positive right of government-enforced accommodations. As Justice Brennan Jr. argued, the framers of the Bill of Rights did not purport to create rights. Rather, they designed the Bill of Rights to prohibit our government from infringing on rights and liberties presumed to be pre-existing. These essential protections have served as the foundation for our rights that we hold dear today. Thank you, judges, and we are now ready for questioning.
All right, thank you very much. So I'll pick up kind of where you left off, which is the difference between positive and negative rights. Isn't this just an academic distinction? It's just a point of view, whether someone protects my rights or I'm afforded rights, it's the same thing in the end, isn't it?
There is something to be said about the fact that with positive rights, the government does have to provide a service. So in something like Gideon v. Wainwright, where you said that you had that right to trial, the government then has to provide that service. So it's costing them something, whereas a negative right just to protect freedom of speech or something, that is not something the government actively has to do unless something like a court case arises. So positive rights, the government is having to provide the service, pay that extra money most of the time. So that's really where that distinction lies.
Add on to the case of Gideon v. Wainwright, a positive right, as applies to the states, can act as an unfunded mandate on states for the right to counsel that incorporated the Fifth Amendment. And now thousands of inmates had to be retried as a result of Gideon v. Wainwright. And our state of Connecticut actually spent $63 million a year as a result of this decision. And positive rights being incorporated to states actually impede upon state rights. For example, with the case of National American Socialist Party versus Village of Skokie, the court now decides that the Chicago suburb must allow Nazis to not march through Jewish neighborhoods, or Kent v. Connecticut, the court decides how states enforce solicitation laws.
Let me follow along this line of thinking a little bit and ask, of the rights that are guaranteed in the Bill of Rights, how may people lose those rights? Or are there circumstances in which they can lose them and get them back?
There definitely are circumstances where they can lose their rights. For example, Florida recently passed a bill saying that that people can run over protesters if they're trying to escape a protest, which obviously is a violation of our First Amendment right. Furthermore, the state of Georgia is now passing new voting laws saying their student IDs are not enough of a voting law not enough of a voter ID to actually vote in the state of Georgia. So students who are coming from out of state and going to state schools like Georgia Tech and Atlanta are not allowed to vote in that state. And these are examples of where we can lose our rights. When people are losing their rights, the best mechanism for preserving those rights are our court system. They can strike laws as unconstitutional and actually allow people to enforce the rights that they hold so dear.
For example, with the Second Amendment gun rights, it was initially meant to apply to militias, to local militias' rights to bear arms. However, with a case like DC v. Heller, the Supreme Court became involved and it incorporated gun rights to apply to private users and to individuals, and it caused that interpretation of the Second Amendment. So that's an example of how the court can actually act to protect our rights, because without courts acting to protect our rights, the Bill of Rights is just a parchment barrier, as Madison initially said.
Okay. Oh, Candida, yeah.
What do you think was left out of the Bill of Rights?
I think a right to privacy could have been included in the Bill of Rights. We've been able to derive it from things like the Fourth Amendment and the Ninth Amendment, but had we written in the Bill of Rights that there was this inherent right to privacy, it would have helped protect from government overreach and would have helped settle disputes that have arisen in the court of how do we derive this right to privacy and is there really one?
Additionally, the right to vote should be in the Bill of Rights, because without our best change happens to the legislature, but without the ability to elect the legislature, we can't have that. In Bush v. Gore, the Supreme Court ruled that there is no right to vote. And in Shelby County v. Holder, it struck down Section 4 of the Voting Rights Act that gave the Justice Department the power to curb racial discrimination in voting. And 43 states are introducing bills currently making it harder to vote, and about 5 million ex-convicts are not able to vote as well.
Any other thoughts? Or Kurt?
Yeah, so sure. So another thing on the right to privacy. So the right to privacy was found from not only the Ninth Amendment, but from multiple different amendments coming together in Griswold v. Connecticut. So it was good that the justices went ahead and created that right. However, it's also important that the majority of the time that creating new rights should be left up not to the courts, but to our legislature, because 9 justices should not be the ones who create new rights. They should only be affirming the rights that have already been created and deciding whether they're constitutional or not.
So let me explore that a little bit more. How do we decide the difference between something that is just good for society, but an actual right? So privacy, great for society, but why is that a right? How do we determine when something becomes a right?
So something is a right if it is found in other parts of the Bill of Rights of the document. For example, with Griswold v. Connecticut, it didn't just use the Ninth Amendment, it used the penumbras of protection of privacy in a bunch of different amendments, versus in a case like Concerned Citizens of Nebraska v. U.S. Regulatory Commission, that was an 8th Circuit Court case. It ruled that there's no right to be free from unnatural radiation under the Ninth Amendment. Just because that's something that's good for the people to not be exposed to radiation doesn't mean there's a right in the Bill of Rights to be free from it.
Furthermore, in Theodore Roosevelt's second Bill of Rights, where he argued that there's a right to healthcare, a right to a fair wage, there's a right to leisure, those things are not enforceable at all. Sure, you can claim that they're good for society, but if there's no way for the government to actually enforce it and make and act upon those rights that you can declare, then there's no point declaring them as actual rights. Things that are held dear and found in the Bill of Rights and are ingrained in the American society are rights, and things that are just good for society or passed as laws are not, especially if they're not enforceable.
Interesting. So do you see a distinction between the rights that are in the Bill of Rights or in the Constitution and those that are, and you've said, created by the courts? And I'd like to explore that. Are they creating them or finding them or recognizing them? And is there a difference between the two?
So in the case of the right to privacy, the justices said that they found the Bill of Rights from combining multiple different amendments together along with the 19th Amendment to create this form of this penumbra, multiple penumbras to protect the right to privacy. And that's really the only time they've touched on the 9th Amendment. They've touched on the 9th Amendment to create a new right. The other time they did it is in Bostock v. Clayton County, where a man who had worked 10 years at a company was fired for joining a gay baseball league. And the reason he was fired, the defendant said, is because he was gay. And they said that since there was no law outlawing discrimination against the LGBTQ community, they were allowed to do that. But in but the court ruled in favor of the man who was fired. And in Gorsuch's opinion, he said that the Equal Protection Clause, even though it mentions discrimination by sex, it actually protects the LGBTQ community too. So he found that right within the Equal Protections Clause.
And in addition to that, going back on our right to privacy, we've seen time and time again, whether it's the case of Griswold v. Connecticut, which we talked about, or Smith v. Maryland, where the Supreme Court rules the right to privacy can be inferred as if it was one of our rights in the Bill of Rights.
Well done.
Fantastic.
Yeah, nice mic drop moment there.
Yeah.
You time it just right. So yeah, all right. Well, we'll give some quick feedback. Richard, over to you.
Well, thank you very much for an informative and a very interesting presentation. I think you should all be very proud of your the knowledge that you obviously brought to this. I thought that the presentation was well planned and well organized. It certainly demonstrated a command of the information that we're talking about. I'm very impressed. Every time when I judge a competition like this, to see high school students with this much knowledge just makes me feel great. You could go on any street in any city in the United States and you guys know head and shoulders more than the average person. And keep up the good work. Stay interested, stay engaged, and you're going to do great. But thank you. You should be all very proud of yourselves.
I agree. I think that was just a wonderful, wonderful presentation. There were so many things that I've circles around, all kinds of things on my paper here. The Skokie, Illinois case, the Florida protest, the your description, the ADA negative and positive discussion was just really right on. It was just beautiful. Privacy issues, Roosevelt right to healthcare, enforcement of these rights, and then vote. I just big circles around the word vote. You just did a really stunning job of answering this question. I'm deeply impressed, and I hope that you're as inspired by your experience learning all of this as we are listening to you, because not only are you going to be wonderful citizens, but you already know way more about the Constitution than anybody in my law school class knew. And so I'm just really looking forward to hearing what you all have decided to do with your lives. Even if it's just being a wonderful citizen, you're way ahead of the game. So I hope you inspire the people around you and seriously consider representing the rest of us. If you do, if someone is in politics or in law or the judiciary, I'll sleep much better in my nursing home knowing that you're all in charge. So thank you. It was a wonderful experience talking with you all.
Yeah, I enjoyed it as well. I'll walk away slightly frustrated, and I'll tell you what I didn't like about it. I ran out of space to write down all the great things you were telling me. I really did. I ran out of space, and I started turning my page sideways, and then I started turning it around. I had to get 2 pencils. It was a great conversation. I really enjoyed this. What I liked is your depth, your breadth, but more specifically, I liked the context that you provided. So we asked a question, you gave me authority, and then you told me why that authority matters. You didn't just spout cases and then expect me to understand why you were citing them. I thought you did a great job, really enjoyed it. One more time. There you go. Yes, one more time. Yeah, good job.
Great.